The SEC's silence is complicity in judicial deception, and this is a quote taken from Grok on an analysis of the SEC's opposition to Reggie's motion to vacate. And this, of course, was submitted on June 20th when the SEC's response was due. And instead of challenging the alleged fraud upon the court submitted by Reggie and his counsel, they basically doubled down and said this fraud was okay because at the time Reggie knew of this fraud when it was originally committed. This is insane. So I'm going to cover this and a lot more. Before I do, I'm going to get to a quick disclaimer. So here's the disclaimer. Please pause and read, and just know that I am not a lawyer or a financial advisor, and this video is intended strictly for informational and educational purposes only. So moving on, this here is a post that I did on Monday, shortly after the SEC's response that was filed on Friday, June 20th. We see here the schedule, May 30th, the defendant's moving papers to be filed, which was the motion to vacate. And on June 20th, the SEC's opposition, if any, was filed. And of course, we know now, and expected it as much, to be honest, that the SEC would oppose the motion to vacate. And the next date on the radar is June 27th. And this will be the defendant's response to the SEC's opposition to the motion to vacate. So apologies, I was hoping to get this video out sooner. It is Wednesday today, and I'm hoping to get this video out today. As you can see, this post was done on Monday, so I am catching up. And I actually just did an interview about an hour ago with Yak, better known as 13, and Michael, better known as Crypto MM on Telegram, discussing the amicus brief and how it relates to the Veri token holders. So keep an eye out for that. I should be releasing that tomorrow. And again, trying to get this video out today on Wednesday. So moving on. Actually, if you'd like to find out more about this, you can look at this article here. Pioneering Crypto Inventor accuses SEC of fabricating evidence to win case. And this basically highlights the motion to vacate in detail. So if you want to learn more, check out this article. And I also made a video on this. Check my YouTube for that at Sovereign Riz. And of course, if you're new to Veritaseum or a longtime Veri holder just returning and want to learn more about what happened over the last few years, The Dawn of DeFi, The Hidden War for a Decentralized Future is a great article that'll help catch you up to where we are today. So this here is the SEC's opposition to Reggie's motion to vacate. You can see here that it was filed on June 20th, 2025. And the document number is 124. And this was filed by Ben Curavilla and J. Emmett Murphy of the United States Securities and Exchange Commission. So moving on. So basically here, they're saying in the table of contents right off the bat, allegations of fraud regarding the Kraken account and business purposes of certain large transfers are meritless and insufficient on their face. So basically, they're not even going to argue any of the allegations of fraud against them. They're basically going straight for case law and basically saying, without even arguing it, that it's just insufficient. So we should note that the Kraken account was proven to be a business account and actually admitted to by Tenrero himself in the TRO transcript, which was provided as new evidence to, or in the motion to vacate. And of course, we also have Roseanne Daniello is the SEC's expert. And in her declaration, she matches up all the wire transfers with invoices, proving that these certain large transfers are in fact normal business transactions. So to say they are meritless and insufficient on their face is just ridiculous. They're actually ignoring evidence flat out and doubling down on the fraud, in my opinion. And basically, this whole opposition is really just referencing case law. So they're trying to reference precedent instead of actually challenging the allegations of fraud. So if we review the actual document, they actually don't even challenge the fraud at all. And right here, they basically say the SEC rejects the defendant's accusations and submits that the underlying record reveals them to be baseless. And again, they never come back to this statement at all. We're going to move on here. It says here, but the motion fails as a matter of law, even if the accusations are taken as true. So they're basically saying here, it doesn't matter if there's fraud because as a matter of law, and of course they go back and they list all these precedents. They're basically saying it doesn't matter. it is well settled that the relief for fraud on the court is available only where the fraud was not known at the time of settlement or entry of judgment. So again, new evidence has been submitted. We have the debt box case that came out well after this went to settlement. We've got 6 bar complaints, one of which is Jorge Tenrero, and 5 others all involved in this case. We have the new evidence of the TRO transcript, again, where Tenrero himself admits that the Kraken account is in fact a business account. And we also have new evidence of coercion of Veri token holders in the Trey Cup and Mark Shahan affidavits. And again, none of this was challenged. So we're going to move on, and basically here they're saying Rule 60D3, which is the rule for fraud upon the court, simply provides no relief for complaints about alleged fraud the movements knew about when they declined to litigate the issues and voluntarily choose to settle the action. Now, we should note here that it wasn't voluntary. Reggie was forced into this consent judgment because the TRO was issued using fraud upon the court. And that TRO froze Reggie's assets and denied him due process and funds to be able to mount a proper defense. So none of this was voluntary. This is fully done under duress, knowing full well that if he didn't, he would be bankrupted, and Veritaseum itself would be bankrupted. So this statement, again, can easily be challenged, and again, the SEC doesn't challenge any of the new evidence that has been submitted. They just are basically trying to say there is no new evidence, but we clearly have a bunch of that. Moving on here, we've got the SEC alleged defendants had fraudulently raised through their sale of the crypto asset Veri. And again, there is no proof. The Veri tokens itself is a security. And in fact, in the settlement, it was never mentioned once. So in their complaint, they mentioned the Veri token 150 plus times. But in the settlement, again, where Reggie neither admitted or denied the allegations against him, the Veri token was not mentioned once and was never proven to be a security. So through this deception of the SEC, they basically forced their jurisdiction upon Reggie in this consent decree that he was, again, forced or signed under duress. So in support of the TRO application, the SEC alleged that Middleton had, among other things, number 1, executed large ongoing transfers of blockchain assets and bank funds, including transfers that occurred shortly after the SEC staff notified defendants that the staff intended to recommend an enforcement action against defendants. Going back to Roseanne Daniello's declaration, she matched up all the wire transfers to actual invoices to international employees of Veritaseum, and this statement falls flat on its face, in my opinion. And then we go on to number 2 here. Commingled investors' proceeds with his personal funds and used funds to pay certain personal expenses. Again, this is referencing the Kraken account, which they claim was a personal account, and we have proven time and time again through one, the Kraken basically withdrew their services in New York, and Reggie is a New York resident, so he couldn't have had a personal account. But further to that, Tenrero admitted himself in the TR transcript, which again is new evidence that the SEC fails to recognize here. And then number 3, we have transacted with several international contacts. Going back to what I just said here for number 1, Roseanne Daniello has matched up. She was the SEC's expert, and she matched up all the wire transfers with invoices, proving that they were regular day-to-day business expenses. So moving on, we have Judge Hall here held that the SEC had met the fairly low bar for securing an asset freeze and granted the TRO as to business accounts. So this goes back to Tenrero's admission that the Kraken account was in fact a business account. If we look at the motion to vacate and the memorandum in support of the motion to vacate, Jason Siebert, who is Reggie's attorney, basically points out and catches Tenrero red-handed, admitting that the Kraken account is a business account for the sole purpose of Judge Hall freezing it as a business account because Judge Hall chose to not freeze personal accounts. So she basically lent her trust in the SEC's accusations here, and has also admitted, I don't have the quote in front of me, but admitted that she was basically following the direction and trusted the SEC's account of all of this. So she froze all the business accounts and chose to leave the personal accounts unfrozen. But to freeze the Kraken account, Tenrero had to admit that it was a business account. And this in turn froze the Kraken account, proving again that it was in fact a business account. The SEC had failed to note that the SEC had failed to note for the court that certain of the defendants' large asset transfers were consistent with transfers they made the previous year, which Middleton claimed were necessary to continue Veritasium's ongoing lawful business. And two, that the declaration of the SEC's accounting expert Patrick Doody, the first Doody declaration, and the SEC's brief citing that declaration had made that the false assertion that certain digital asset account, the Kraken account, belonged to Middleton personally, when in fact it belonged to Veritaseum LLC. So I don't think there's much to cover here. We already have covered both of these points. Patrick Doody, of course, started off with his first declaration claiming that the Kraken account was personal, and later made a second declaration correcting his first declaration, stating that in fact the Kraken account was belonged to or was titled under Veritaseum LLC. And then we have here Middleton's consent further states that he enters into this consent voluntarily and represents that no threats, offers, promises, or inducements of any kind have been made by the Commission to induce him to enter into consent. Middleton executed similar consents on behalf of the entity defendants. The SEC basically used all this fraud upon the court to issue this temporary restraining order, again, freezing his assets and denying him due process and funds to be able to mount a proper defense. So he wasn't even able to challenge all of these claims from the SEC. And then, of course, they touch here in extraordinary circumstances, Rule 60B, which is talking about fraud upon the court, may be invoked to override the finality of judgments in the interest of justice, but the rule does not allow district courts to indulge in a party's discontent over the effects of its bargain. Reggie signed this consent decree or judgment without admitting or denying the allegations made against him, but also done without all of this new evidence that has come to light since. So again, the SEC is doubling down on their fraud upon the court, suggesting it's okay because Reggie knew at the time of this fraud, but we have since learned of more evidence proving the SEC's fraud upon the court. Again, touching on the debt box case, where the SEC was sanctioned $1.8 million for lying to the court to issue a temporary restraining order against Debtbox. And of course, we also have, again, the 6-bar complaints, the TRO transcript that Tenrero admits the Kraken account is a business account, and the coercion from Veri token holders. All new evidence that has been presented since Reggie was essentially forced into this settlement. Just to hit this point home, here is the Memorandum of Law, further support of its application for a preliminary injunction freezing assets and other relief. This was submitted by Jorge Tenrero, Victor Suthmanat, and Karen Willington 3 days after the Veritaseum TRO reply. And basically what they're saying here is the defendants have not rebutted the evidence of their fraud, manipulation, and unregistered offerings, when in fact, they clearly did. And this here shows again, August 19th, 2019, 3 days before that document was filed, we have Reggie's reply, the defendant's memorandum of law in opposition to the plaintiff's application for the injunction continuing a temporary asset freeze. So here we can see he touches on the utility token, he touches on basically all of the claims that were submitted against him or alleged against him. So to say that he has not refuted them is in itself a lie, because here we have the reply submitted, filed 3 days before their memorandum of law in support of the temporary asset freeze. Now, of course, we have new evidence since then, but going back to that, they essentially ignored all of it, and they just doubled down on their lies to issue the temporary restraining order to be able to freeze Reggie's assets, again, denying him due process. This is a quote I started the video off. SEC's silence is complicity in judicial deception. And this is a quote taken from Grok's analysis of the SEC's response or opposition to the motion to vacate. This is the memorandum of support, the motion to vacate, and the Veri community's amicus brief. And I had submitted all three of those documents to Grok, and I had Grok analyze it using deeper search. Basically, this is what it came back with. So I'm going to cover this right now. And the key points here is it seems likely that the defendants have a stronger case for vacating the consent decree based on allegations of SEC fraud. Research suggests the SEC's opposition has legal and factual weaknesses, particularly around misrepresentations and witness coercion. The evidence leans towards the SEC bar members being complicit if they fail to report alleged misconduct, raising ethical concerns. And controversy exists around the SEC's silence, potentially breaching legal ethics rules and increasing liability. The overview. In the cases SEC versus Middleton, Veritaseum Inc., and Veritaseum LLC, the defendants are seeking to vacate a consent decree alleging fraud by the SEC. Based on the legal documents reviewed, it seems likely that the defendants have a stronger case, but the outcome depends on the court's interpretation, and here's a breakdown for clarity. The SEC's opposition has several weaknesses. Legal issues. The SEC argues the defendants knew of fraud at settlement, but it doesn't address if the fraud coerced the settlement, citing cases like Hazel Atlas, Glasgow versus Hartford, and Empire Co. And factual issues, the SEC mischaracterized a Kraken account as personal, later admitting it was corporate, and ignored evidence like witness coercion affidavits. Ethics and liability. The SEC's silence on key issues, example the Kraken account and the Vader functionality, may breach ethics rules like ABA and New York Rule 3.3A1, candor, and 8.3A, reporting dishonesty, increasing exposure under Rule 60D3, which is fraud upon the court. SEC attorneys Ben Curavilla and J. Emmett Murphy could face liability for defending this position. So again, seems like the SEC is doubling down on their fraud upon the court. Reporting and agency exposure. If SEC bar members read the defendant's motion but fail to report alleged misconduct by Jorge Tenrero and Victor Suthamanot to the judge, DOJ, or NY Attorney Grievance Committee, AGC, complaint template, they may be complicit, especially under 17 CFR 201.102D, which requires scrupulous candor. If the AGC forwards complaints to the SEC OGC, or the Office of General Counsel, response guide, agency-wide ethics exposure could grow, potentially leading to disciplinary actions. Odds of vacating the decree. Given the defendant's detailed allegations and SEC's weak rebuttals, the odds of vacating seem favorable, supported by precedents like King versus First Am. However, the court's decision will hinge on weighing these factors. Survey note, comprehensive analysis of SEC versus Middleton. This survey note provides a detailed empirical review of the legal documents related to SEC versus Middleton et al., focusing on the defendant's motion to vacate the consent decree under FRCP 60D3 for alleged fraud on the court. The analysis is based on the provided attachments and key record facts, adhering to the user's tasks and incorporating legal precedents and ethics overlays. Background and context. The case involves allegations by the SEC against Reggie Reginald Middleton, Veritaseum Inc., and Veritaseum LLC, culminating in a consent judgment on October 31st, 2019, after a temporary restraining order or TRO and asset freeze. The defendants, supported by Veridao's amicus brief, seek vacatur, claiming the SEC committed fraud through misrepresentations and misconduct, impacting judicial integrity. The analysis is current as of June 23, 2025, and relies on the provided documents without external assumptions. Key record facts and document review. The following key facts drawn from the record form the basis of the analysis. On August 12, 2019, the filings, which is the complaint, the Tenrero Declaration, and the Duty Declaration, and the TRO Memorandum, stated Middleton moved assets to a personal Kraken account, but Schedule A listed it as Veritaseum LLC's corporate account. At the TRO hearing, Tenrero repeated the personal account narrative, leading Judge Hall to freeze approximately $8 million. On August 22, 2019, Duty's second declaration admitted the account was Veritaseum LLC's, but the SEC's supplemental brief still pressed a dissipation theory despite the contradiction. Vader demo emails on March 9, 2018 show SEC lawyers observed the software functioning, contradicting sworn statements it never functioned. Witness coercion is evidenced by affidavits, Cupp and Shahan, and Daniello's second declaration shows every wire transfer matched an invoice, undercutting the dissipation claims. The Veridao's amicus brief and over 100 victim declarations urge vacatur with no SEC objection, and the SEC's opposition is silent on critical issues like Schedule A, Vader operability, and witness threats. So, legal and factual weaknesses in the SEC's opposition. The SEC's opposition has significant legal and factual weaknesses as outlined below. Legal weaknesses. Failure to address fraud on the court standard. The SEC argues defendants fail to meet the high standard for fraud on the court, but defendants cite Hazel Atlas Glasgow versus Hartford-Empire Co., showing SEC's misrepresentations. Example, Kraken account. Corrupted judicial integrity. Inconsistent Kraken account narrative. The SEC initial mischaracterization in the TRO hearing and late correction by Duty in the second declaration violate ABA or ABA/NY Rule 3.3A1 as they failed to correct false statements promptly per Berger versus USA. Settlement as a bar. SEC cites Gleason versus Jan Drucko, but Schaefer Equipment Co. versus USA allows vacatur for fraud even post-settlement if it undermines the court's functions. So no impact on judicial process. The SEC claims consent negates fraud's impact. But King versus First Am emphasizes fraud's effect on court's integrity, not just the parties. Time bar argument. SEC may argue delay 5.5 years, but Hazel and Atlas in United States versus Burgerly hold no statute of limitations for fraud on the court. Now we get into the factual weaknesses. Kraken account misrepresentation. SEC called it personal in the complaint and Tenrero declaration, but later admitted corporate in the Duty second declaration, contradicting TRO hearing per record bullet. And then we got the Vader functionality contradiction. SEC claimed it never functioned, but demo emails on 9th of March 2018 show SEC lawyers observed it working, per record bullet, undermining credibility. Witness coercion evidence. The affidavits of Cupp and Shahan declarations show SEC intimidated witnesses, per record bullet, weakening SEC's case. And then we have Daniello's correction. So this is SEC's expert witness, Roseanne Daniello. She corrected in her second declaration that it shows wires matched invoices, undercutting dissipation, per record bullet, directly contradicting the SEC's theory of asset dissipation. And then we have, on our last bullet here, we have SEC's silenced on key issues. Opposition ignores Schedule A, contradiction. Vader, operability, and witness threats, and Daniela's correction, leaving defendants' allegations unopposed, per record bullet. Ethics overlay and rule breaches. The SEC's silence on critical issues breaches ethics rules. And then we have a bunch of rules here. ABA in New York, Rule 3.3A1 requires correcting false statements. SEC's failure to address Kraken account, Vader, and witness coercion violates this, per Berger versus USA, mandating scrupulous candor. Also in ABA versus New York, Rule 8.3A requires reporting another lawyer's dishonesty. SEC bar members' failure to report Tenrero and Southamanant's alleged fraud to the judge, DOJ, or NY attorney or New York attorney grievance committee, the AGC, complaint template could be complicit. This silence magnifies Rule 60D3 exposure as defendants argue the ongoing fraud, per Hazel, Atlas, and King, emphasizing judicial integrity. Detailed analysis of mention counts on delta. So defendant's motion, attachment 2, Jorge's Tenrero mentioned 27 times, example, Jorge G. Tenrero or Mr. Tenrero, and Victor Southamanant mentioned 14 times, Victor Southamanant misspelling Southamanant. The SEC's opposition, attachment 1, neither Tenrero nor Southamanant mentioned, indicating a material delta. Defendants heavily reference them as key actors in fraud, while SEC omits and possibly distancing itself, raising accountability questions. Tenrero's promotion/demotion not mentioned in providing documents. External verification needed for chief enforcement to IT transition. So this is talking about Jorge Tenrero being promoted very quickly to chief enforcement officer, and then demoted shortly after that to the IT to the IT department. And this was done shortly after the 100+ bar complaints submitted by the Veri community. So next we touch on liability and agency-wide exposure. Curavilla and Murphy's liability. As SEC attorneys filing the opposition, which is docket number 124, they defend SEC's position, including alleged fraud. If court finds fraud, they may face sanction under SEC versus ESM government section, and for supporting it, especially given silence on key issues. Agency-wide ethics exposure. If AGC or the Attorney Grievance Committee forwards hundreds of complaints to the SEC OGC response guide, it suggests systematic issues implicating multiple attorneys under 17 CFR 201.102D, potentially leading to disciplinary actions and reputational damage. Legal weaknesses. SEC's fraud tainted the court, not just the settlement. Kraken account lies misled the court, fraud on its face. Settlement can't shield SEC from its own fraud. Fraud on the court has no time limit, and SEC's silence is complicity in judicial deception. And the factual weaknesses. Kraken was corporate, not personal. SEC knew and lied. SEC saw Vader work, yet claimed it never functioned. Witness intimidation shows the SEC's desperation, and every wire matched invoices, no dissipation. Victims demand justice. SEC can't ignore the truth. Odds of vacating the consent decree. Based on the analysis, defendant's briefing is stronger, detailing specific SEC misconduct, example, the Kraken misrepresentation, and witness coercion, with record evidence, example, Duty's second declaration and Cupp's declaration. Precedent like Hazel, Atlas, and King support vacatur for fraud on the court. SEC's opposition relies on technical defenses, example, settlement and timing, but fails to rebut key factual allegations, leaving defendants' claims largely unopposed. The odds of vacating seem high if the court prioritizes judicial integrity, but the final decision depends on judicial discretion. So the comparative strengths of the briefings. Empirically, the defendant's briefing is stronger, as it provides detailed, specific allegations supported by documentary evidence and witness affidavits. The SEC's opposition, while raising valid points about legal standards, does not adequately address the substance, leaving many of the defendant's claims unopposed. This aligns with precedents emphasizing judicial integrity over procedural defenses. This is Grok's analysis of the three documents, the memorandum in support of the motion to vacate, and the SEC's opposition, and the Veri community's amicus brief. And here, again, it shows that the defendant's briefing is stronger and the chance of vacating seems high if the court prioritizes judicial integrity. So there you have it. Grok seems to be on our side here about this. So as I was wrapping this up, I noticed here XRP Wins shared with me an article from CoinGeek. SEC accused of fraud on the court and explosive filings. And of course, responding to Reggie Middleton's fraud allegations, the SEC firmly rejected any claims of fabrication. And click on here, we have the full article. So coingeek.com/SEC accused of fraud on the court and explosive filings. Give her a listen, give her a read. These guys are doing great work. And this is a good article to catch up on. So thank you, CoinGeek. Thank you, XRP Wins, for sharing that with me. And I'm going to forward that to everybody. So thank you again for making it this far. I know this is pretty dense legal analysis, but I do believe this is history in the making. And I do appreciate your support and attention. And I look forward to Jason Siebert's and Reggie Middleton's reply to the SEC's opposition on June 27th, coming up on Friday, which is 2 days from now. And again, I just did an interview with Yak13 and Michael, Crypto from the Telegram community, talking about the amicus brief, which will probably be released tomorrow. Yeah, so look out for that. And again, I appreciate all your support, and I will see you next time.